delighted to introduce David Jepsen on the videocast today here in the Experience Center. David Jepsen is our Global Chief Policy Officer for NTT Corporation, which includes our subsidiaries like Docomo and NTT Data. David, welcome to the videocast.
Thanks, Megan. I'm happy to be here.
So help us understand a little bit about your background and role in NTT.
Sure. I've either been working directly for or with NTT now since 1997, so about 27 years. I graduated law school in Washington, D.C. in 1990, and have been doing government relations work ever since. And in the late 90s, I was an expat for Lucent Technologies in Japan when NTT was beginning to really strengthen its partnership with global vendors. From there, NTT Docomo was going global, and they hired me to open up a Washington, D.C. office and be their chief representative in Washington, D.C. And when NTT bought out the rest of Docomo recently, I joined the holding company to take on a global role and help advise on their government relations strategies worldwide.
Oh, wow. So today I understand that we're going to talk about how governments are struggling with AI. It's a really big issue and they're looking to regulate, and it's challenging, I understand. So what do you suggest we should watch out for?
Yeah, so look, when ChatGPT came on the scene in late 2022, it was an urgent wake-up call for governments worldwide. They're concerns about trustworthiness, privacy, security, authentication. The list goes on and on. The first area that has attempted to regulate the AI industry has been in the EU with the passage of the EU AI Act just recently by the European Parliament. Now, that's the first attempt by any regulatory government body to comprehensively regulate AI and to do it on a worldwide basis. There's some challenges with how far it can extend, but this is the biggest effort to regulate in the AI area.
Well, help us understand more about this EU Act and also how the framework that they've created that other governments can benefit from.
So the EU Act follows a risk tier model. It defines certain categories as just unacceptable risks that will be banned right out. And then it has other risk levels for different applications, different systems that will have varying compliance obligations.
Right, I understand. So it's a framework of levels of risk. So what are some examples of completely unacceptable risk?
So some examples of the unacceptable or completely banned list. One would be social scoring based on some personal characteristics. The other would be exploiting any vulnerabilities in terms of age, race, social, economic status. But then more to the level of business that NTT does, there's a restriction on facial recognition systems if some of the images have been scraped from the internet or from CCTV. And on facial recognition, I suspect there's going to be more rulings coming out to really regulate that space. And then there's also a ban on so-called sentiment recognition systems, or systems that infer emotions on people in the workplace or educational systems.
I understand. So there's a lot of tinkering going on for productivity in the workplace. Workplace AI, I think they're calling it. Help us understand, some of the issues that could there and what could very likely be banned that folks are working on.
So for example, if any enterprise is looking at using a sentiment recognition system, thinking it would help improve productivity or customer relations business, that system is now completely banned. Within 6 months, of the Act's effective date, it will have to be shut down. But what I would say just generally is that any enterprise looking at implementing AI in the workforce should be scrutinized very closely for its compliance with the Act. Indeed, in this high-risk category underneath unacceptable risks, the EU Act defines any application that manages the workforce or gives employment evaluations.
Oh, interesting.
Now look, when it's high risk, it's not banned outright like the unacceptable risks.
Right.
But it has really complex and reoccurring safety assessment requirements, and in some cases, a registration requirement directly with the EU authorities.
So it's exciting that the EU's done this work. It's a starting place for other governments. Can you help us understand if it only works in Europe or companies in Europe?
Yeah, so much like what happened in the EU with its passage of the GDPR, the landmark privacy bill, this act has many ways it's going to have extraterritorial impact. The act defines any importer, distributor, developer, anybody in the system that exports to the EU the system that is in question and used in the EU, it will apply extraterritorial to those entities that help develop the system. So this is a way, much like with what happened with GDPR, that it will have a broad global extraterritorial effect, particularly since AI is being developed globally.
So there must be other things in the EU AI Act that stood out to you, especially you mentioned developers.
Yes, the developers will be under scrutiny for any system that doesn't comply with the act. There are some other provisions in it, though, that I found really interesting. One was a encouragement that any developer of AI systems or provider of those systems assess the environmental sustainability of those systems.
Oh, wow. So our data center business is quite unique in that we're very focused on sustainable data centers. Is there anything else you can say about sustainability?
Yeah, so as you know, I think NTT has been laser focused on sustainability, not just to help our customers be more energy efficient, but to also play our role as a good corporate citizen and lead to a better society generally. And everyone knows that AI will be a really useful tool to help lead to a more sustainable future. But to power strong AI systems itself is an incredible stress on the power grid itself. By some calculations, some of these large LLM models will soon be using more power annually than the entire power of a mid-sized country like Sweden, Norway, or even Japan.
Wow.
And so this is where NTT's leadership in the effort to evolve our transmission and compute platforms from an electronics-based system to all photonics-based system, what we refer to as IOWN,
Yes.
is now critically important.
The Innovative Optical and Wireless Network, IOWN.
Correct. Yeah, because in order to enable these type of systems, we're going to need an entire new approach to how our information is transmitted. And, if there's one thing we can conclude about AI at this point is that the demand for ever-increasing computing processing is only going up. So in this area, that's why I think IOWN has now become a super important movement.
Understood. Yes. IOWN is very important for us to understand that there's a set of technologies under IOWN. It's not just networking or even compute like optical chips and networks, but it's also all the software and a whole ecosystem and a way of thinking that vastly increases the productivity and efficiency of computing in general.
Super well said. Yeah, I completely agree.
So help us understand a little bit about the differences between what you're seeing in the way that the EU AI Act is going and how the US is looking at their regulations.
Sure. As you and I have talked before, the US is such a polarized Congress right now that it's very unlikely we will see any sort of comprehensive legislation on AI. That is not to say that the U.S. is just sitting back on its hands here. They are doing some things to try to regulate in this space to the extent they can. The framework to look at in the U.S. is the executive order that came out of the Biden White House recently. Now, the executive order just applies to federal agencies, but that will impact how private industry develops AI in a couple of different ways. One is there is an obligation on any regulatory agency, such as the FCC, the FTC, the SEC, that regulate a large portion of our private industry. They now have an obligation to set rules on the companies they regulate. And another way it will have an impact on how systems are developed here is through the federal government's role as being the largest buyer and consumer of AI systems. Any federal agency that is procuring an AI system will have to file very strict red teaming safety protocols, and those protocols will be extended to their federal contractors. And since the market for AI systems that will be the biggest buyer of those systems, that will impact how those systems roll out in the private marketplace as well.
So it sounds like governments are doing a lot to look at this space, to look internally within the various organizations of the government and agencies, and that this will also have a spin-off effect onto enterprises and to companies. Is there anything that you think governments should do and companies should do to comply?
Yeah, yes, I will get to that, but just to make that point that the U.S. government is active in this area, even though there has been no large legislation passed, I'd bring up the activity going on right now at the FTC under its current authority to regulate privacy. They are looking into any enterprise that is using worker information to feed in and train an AI model. If they do not have clear written consent from the workers, they are going to enforce and stop that sort of activity. So it's critically important that any enterprise trying to use worker information to train an AI system have clear written consent from their workforce that they're getting that data for. For example, there's a lot of applications now on auto transcription of a meeting or translation of a meeting. And if that data is being shipped off to train an AI model and there was not clear written consent from the people involved in the meeting, there's a problem with the FTC.
Oh, wow.
So these are just another example of why any enterprise use of this.
Let's repeat that for our audience. So when a meeting is recorded and that transcript information is used without the full consent of all the meeting participants, you potentially could have a problem with the FTC?
Correct.
Wow, that is something for us to all pause and think about,
Yes,
because you think about the number of recorded conversations happening these days.
And for enterprise use, you want to try to make your enterprise more efficient, and so you've trained the model with your worker information.
Right.
It's critically important now to have your in-house lawyer make sure everybody is aware and informed consent, not just a privacy policy with small letters. It has to be understood and
informed consent.
Informed consent.
Yes, I agree that all of the meetings as an employee that I'm on can be recorded and used.
Correct.
In models.
Correct.
That's a big thing to sign off on for an employee.
Correct. And we'll see how that new way of interacting with your workforce develops, right? You wouldn't want that.
You're going to have shadow meetings in like their own personal email accounts and things so that they aren't recorded. That kind of thing.
Exactly. Yeah. Now, as far as what governments can be doing and should be doing that they aren't, and this is just my personal opinion, by the way, but I think it would be very helpful if they make it a clear statement that Section 230 was the broad exemption from litigation that was given to the internet platforms as the internet was being developed. Make clear that broad exemption from litigation does not apply to AI systems. That will be a key deterrent from anybody seeking to use AI for bad purposes. In our system, the federal government's ability to enforce its regulations and its policies, especially nationwide, is very limited. And this is where using our legal system and our tort laws can have a much more effective enforcement effect and cause a deterrent effect against bad actors than trying to regulate it, enforce it all from a federal agency. And I would say on that as well, it's important to do this soon, before the elections coming up this fall. It's not just the U.S. There are 70 countries this year that have elections going on, and they're all incredibly concerned about deep fakes, AI-generated deep fakes, and the ability to misinform the populace in their elections. If we can get the clear statement on Section 230, that would hopefully deter any entity thinking they could be sued quickly by a private legal system from taking those kind of actions. If they think they're immune from lawsuit, I think we'll see some very bad activity during these elections. In that regard, I would just note this, Megan, I don't know your thoughts, but I think in a lot of ways we've already lost the misinformation war with deep fakes. If you think about it, most of the population around the world now is aware that AI can generate incredibly realistic deep fakes. And so in a polarized world, there's a situation where nobody knows quite what to believe. Just an example, the Princess of Wales situation. There was a crowd that wanted to believe that was an AI deep fake, generated fake. There was another part of the population that said, no, it wasn't. And since we don't have yet what's known as a common watermark system where everybody will know what is a computer-generated AI content, we're going to have this confusion in the world. The other area that this has happened is in the Gaza-Israeli conflict. There have been some situations where people want to believe that image was a fake AI-generated material, and there's another that think it was real, and so we've already kind of lost this information battle, in my opinion. And
just because the capability exists,
just because it exists, right?
Yeah.
Another area that I just bring out too that it would be important for governments to focus on is giving clear guidance of what the copyright law situation is in AI. Right now, the large LLM providers in particularly are taking a really aggressive interpretation of the fair use clause of the copyright law in gathering all of the data off of YouTube, off of the internet,
right,
and training their models. And the key thing to watch in this is the lawsuit was filed by the New York Times against OpenAI.
Right.
Now that will try to settle and give us some guidance, but that process will take a couple of years, and then it could be appealed. So it might take a while to get some clarity from that lawsuit. This issue has been presented to the Office of Copyright and Patents, which is usually a very low-key, sleepy agency, but now they have the ability to really give some guidance that could help straighten out this issue about what sort of information can go into is copyrighted, and what rights those copyright holders have when it goes into an AI training system.
Well, I'm blown away by the complexity of this challenge. There's obviously the technical level about what you're allowed to do literally on the internet and what will be sort of stopped at that point, which is actually kind of helpful, right? Because there is, to some extent, the data center and the network. And then there's just like the way that on the other side, the way the society responds to what they see and what they believe they're seeing, which is the whole other end of that spectrum. So there's a lot to do here, isn't there, David?
We're still looking at some real challenges to make sure that this is rolled out in a very responsible, productive way. So there are a lot of challenges.
Well, I'm glad you're here to help the company and help all of us to understand these issues, to break it down and clarify it. And we've also done a previous interview on some of the topics around this area, the executive order on AI and zero trust. So you can find that podcast interview on global.ntt. It's been great to chat with you, and I hope you come back
Super.
and keep us abreast of what's
Let's
happening.
keep in touch, Megan.
Yes.
I really enjoyed this. Thank you.
Thank you.